And really a larger problem is that you have these federal laws, namely the Clean Water Act. The Clean Water Act prohibits the discharge of a pollutant into a water body of the United States. Essentially, each one of those specific terms are terms of art that have been enunciated in case law. So you have to prove that there's a discharge, a pollutant, into the waters of the United States by an entity. The problem comes in if you're not classifying something as a residual waste and you don't have testing on hand to prove exactly what came out of the well and what the full composition of those waters are, you're never going to be able to prove that you put a pollutant in there, and then you're never going to be able to assess liability against the company. So to be able to do that really requires a lot of these other things we're talking about. We need to know exactly what, how much, when, and how it's all happening. Once you understand the semantics of how they're going about doing this, you can start doing these larger, broad-scale attacks against companies that are doing these discharges. But because of the immensity of the problem and because so much of it is tied up in a state DEP's ability to have paperwork shuffling, for instance, I cannot look up, I will see a permit notice when they have an initial application for a well to be drilled. And then there will not be any more notice after they re-simulate it for time after time after time. I have to physically go up to the DEP office and know exactly which well in which county and requisition those specific records, which will take 3 to 4 weeks. And then I have to set up some sort of a parameter to get access rights to go onto that land, and then I have to know which parameters to monitor for and to send in a test for each one of those chemicals, which alone, each one of them would be $50 to $100 to monitor for each one of them. And I have to do this for a length of time such that I can prove in a court of law that this is a discharge of a pollutant into the water of the United States. Again, where's the onus here?
And I understand that, but as, for instance, your farm,
yeah.
Can you do some baseline testing now?
Well, we've done baseline testing on water flow, as well as looking for things that might show up from gas drilling. But your basic question, I want to say that there are a lot of things percolating right now about suits at the federal level under the NEPA Act. I think there were just 5 organizations that got together to go after the Delaware River Basin Commission, particularly the Army Corps of Engineers head of that commission, but to say that they have not complied with the requirements of the NEPA Act for a comprehensive environmental review. In our state, Pennsylvania, there are no such laws, but in the state of Maryland, the state of New York, those states can go back to some of the legislation they have on the books that require comprehensive environmental reviews of this type of industrial activity. Pennsylvania doesn't have that, and we've talked to lawyers about that, and they've said that probably our best scenario there is to go to the federal level and look for some sort of way to do in law what our legislature should have done years ago, which was to require this kind of environmental review.
I guess what